The public, which generally watches too much television, will commonly think of a restraining order as a judge's order that keeps an abuser from coming into contact with his victim in a domestic violence case. While this might be the case in California or New York where television shows and movies are made, Texas is very, very different. First, and most importantly, in Texas, there is a distinct difference between what is called a restraining order versus a protective order. These terms are not interchangeable and refer to two very different concepts. There are, for our purposes here, really two overall categories of orders in Texas that keep one person away from another. The first is a restraining order. There are also protective orders issued both under the Texas Family Code and under the Texas Code of Criminal Procedure. A restraining order can be filed after or in conjunction with any civil lawsuit, and one person can seek a restraining order against any other person for a variety of reasons. For instance, one neighbor might apply for a restraining order against another, or an employee may apply for a restraining order against a former boss if a lawsuit is in progress. One of the most common restraining orders accompany a filing for divorce. This restraining order might prevent one spouse from taking actions such as taking money out of a joint bank account or harassing the other spouse. Restraining orders are civil orders which are not criminally enforceable. In other words, should a person violate a restraining order, the victim will have to go before the judge, where the judge may or may not find the violator in contempt of court. The punishment may include simply a warning from the judge not to do it again or a fine. Jail time is not guaranteed, so you can see how a restraining order would be very ineffective at keeping someone like a violent family violence abuser away from his victim. The category of orders more relevant to criminal law include protective orders, or what might be informally called a permanent protective order, and a more temporary version of these called an emergency protection order, which are discussed much later in the Code of Criminal Procedure. For right now, we'll ignore emergency protection orders. While you can seek a restraining order against almost anyone for almost any reason in conjunction with a civil lawsuit, only the victims of family violence, child abuse or neglect, continuous sexual abuse of young child or children, indecency with the child, sexual assault, indecent assault, trafficking of persons, bias or prejudice offenses, essentially hate crimes, compelling prostitution, and stalking are eligible for a protective order. Remember, restraining orders are not criminally enforceable. In other words, if a person violates a restraining order, it's a civil matter. The police won't be involved, and the violator is not going to jail. But protective orders are most definitely criminally enforceable on the spot. Should you violate a protective or emergency protection order, you're most definitely going to jail. So, a violation of a protective order requires a police response and imposes criminal penalties, including jail time, on someone like a family violence abuser if he takes an action which a judge has forbidden him to do. You can see why these types of orders are reserved to protect victims of hate crimes, stalking, sexual assault, forced prostitution, human trafficking, and family violence. Peace officers may frequently come across situations which involve family violence protective orders. The Texas Code of Criminal Procedure provides specific instructions on how to proceed when a person presents an officer with a copy of a family violence protective order. It's most common a peace officer will be made aware of a family violence protective order because it will be linked to individuals and addresses in a police agency's computer-aided dispatch system. The actual protective order, the one signed by the judge, will be on file elsewhere, say with the county clerk, district clerk, or in the police agency's records section. There is a possibility, however, a protective order may be so new that it may have not yet been entered into the dispatch computer system, or the piece of paper may still be in transit from the judge to its final destination. The peace officer may therefore show up and have a victim show him or her a copy of a protective order and have no other means to verify the order. The Code of Criminal Procedure states, peace officers shall accept a certified copy of an original or modified family violence protective order as proof of the validity of the order and presume it to be valid unless the termination date has passed, it is more than 1 year old from the date of issue, or the officer has been notified the order has been vacated, or in other words, he or she finds out it is no longer valid. Next, remember the Code of Criminal Procedure states a peace officer who investigates an alleged family violence offense shall prepare a written report. It also goes on to specify the peace officer shall provide the report information to the Bureau of Identification and Records and the Department of Public Safety. Finally, the Code of Criminal Procedure states the venue for the penal code offense of violation of a protective order or repeated violation of protective orders or conditions of bond in a family violence case is either the county in which the order was issued or, without regard to the identity or location of the court that issued the protective order, the county in which the offense was committed. So, ordinarily, a person who violates state law is prosecuted in the county where the offense occurs. So, a person who commits a crime in County A is prosecuted in County A, and a person who commits a crime in County B is prosecuted in County B. Remember, a protective order is a civil order which is criminally enforceable and is reserved only for certain violent crimes and family violence. Keep in mind, too, family violence protective orders are found and issued under the Family Code. This section of the Code of Criminal Procedure essentially adds more flexibility for prosecuting violations of family violence protective orders by stating if the order is violated, no matter where it's violated, the offender can be prosecuted in either the county where the offense was committed or taken back to the county where the order was issued. So, if County A issued the family violence protective order, but that order is violated and an arrest occurs in County B, then the Code of Criminal Procedure allows the offense to be prosecuted in either County B or in County A. Earlier in the Code of Criminal Procedure, we talked about types of judicial orders that protect victims from the alleged offenders. As you might recall, the first type of order is a restraining order. In Texas, a restraining order is a civil order, and anyone can seek a restraining order against almost anyone else for almost any reason in conjunction with a civil lawsuit. For instance, one neighbor might apply for a restraining order against the other, or an employee may apply for a restraining order against a former boss if a lawsuit is in progress. One of the most common restraining orders accompany a filing for divorce. Restraining orders are not criminally enforceable. In other words, if a respondent, the person whom the order applies to, violates a restraining order, the person the order protects must report the violation to the judge who has issued the order, and the judge may decide to hold the respondent in contempt of court. The next type of Texas order we discussed earlier is a protective order. While you can seek a restraining order against almost anyone for almost any reason in conjunction with a civil lawsuit, only the victims of family violence, child abuse or neglect, continuous sexual abuse of young child or children, indecency with a child, sexual assault, indecent assault, trafficking of persons, bias or prejudice offenses, essentially hate crimes, compelling prostitution, and stalking are eligible for a protective order. Protective orders are civil orders that are criminally enforceable. Remember, if a respondent violates a restraining order, the person who obtained the order must contact the court. If a respondent violates a protective order, the protected person should call the police. We're going to add one more type of civil order that is criminally enforceable, which is covered under the bail section of the Code of Criminal Procedure: emergency protection orders. Under the Code of Criminal Procedure, at a defendant's appearance before a magistrate after an arrest for family violence, trafficking of persons or continuous trafficking of persons, sexual assault or aggravated sexual assault, or stalking, the magistrate may issue an order for emergency protection, or an EPO, at the magistrate's own motion, or the request of the victim, a peace officer, the guardian of the victim, or the prosecutor. At the defendant's appearance after arrest for an offense involving family violence, the magistrate shall issue an order for emergency protection if the arrest is for an offense that also involves serious bodily injury to the victim or the use or exhibition of a deadly weapon during the commission of an assault. In an emergency protection order, the court may order the defendant to refrain from committing family violence or an assault on the protected person, stalking the protected person, prohibit the defendant from communicating directly with the victim or their family or household in a threatening or harassing manner, or in any manner except through an attorney if the magistrate finds good cause, going to or near the residence, place of employment or business, or child care facility or school of the victim or the victim's family or household, and possessing a firearm unless the alleged offender is employed as a peace officer. In an EPO, the magistrate shall suspend a license to carry a concealed handgun if the defendant has one. In an emergency protection order, the court may also order the defendant to wear a GPS device at the defendant's own expense. At the victim's expense, the court may provide a GPS proximity detector, which would essentially notify the victim if the defendant was close. The victim of the offense need not be present when the EPO is issued. If applicable, the court shall specifically describe each prohibited location and the minimum distance from the location unless that information is confidential. An EPO issued under this article takes priority over any other existing orders unless the order has been issued under certain titles of the Family Code. The magistrate issuing an EPO shall send a copy of the EPO to the chief of police in the city where the victim and their family resides, or to the sheriff of the county where the person resides, not later than the next business day. It shall also be sent to any school or child care facility described in the EPO. If the victim is not present when the EPO is issued, the magistrate shall order an appropriate peace officer to make a good faith effort to notify the victim of the EPO within 24 hours by telephone. That peace officer shall call the victim's residence or place of employment. The clerk of the court shall send a copy of the EPO to the victim not later than the next business day. An EPO is effective immediately. The defendant shall be served a copy in person or electronically by the magistrate or the magistrate's designee, and a separate record of service shall be made. An EPO for family violence, sexual assault, aggravated sexual assault, stalking, or involving serious bodily injury to the victim remains in effect up to the 61st day, but not less than 31 days after the date of issuance. An EPO for the use or exhibition of a deadly weapon during the commission of an assault remains in effect up to the 91st day, but not less than 61 days after the date of issuance. After notice to each affected party and a hearing, the issuing court may modify all or part of an order issued under this article if the court finds that the EPO as originally issued is unworkable. The modification will not place the victim of the offense at greater risk than did the original EPO, and the modification will not in any way endanger a person protected under the EPO. To ensure that an officer responding to a call is aware of the existence and terms of an EPO, each police department or sheriff shall enter an EPO into TCIC no later than the third business day after receipt. A victim, guardian of a victim, or close relative of a deceased victim is entitled to the following rights: the right to receive from law enforcement agencies adequate protection from harm and threats of harm arising from cooperation with prosecution efforts, and the right to be informed when requested by a peace officer concerning the defendant's right to bail and the procedures in criminal investigations. Finally, remember, if a respondent violates a restraining order, the person who obtained the order must contact the court. If a respondent violates a protective order or an emergency protection order, the protected person should call the police.